So, does anyone actually own their home in the Vancouver area right now? What about the rest of British Columbia? Is there going to be a problem with right and title to home ownership, land ownership across the country? Hello, and welcome to the Full Comment Podcast. My name's Brian Lilly. You may have heard a little while ago about a court case called Cowichan Tribes versus Canada. In it, a parcel of land of about 14 acres was handed over to the Cowichan tribes. It's currently owned by other people, but the right and title was said to belong to the tribes. It's unclear what that means, but plenty of homeowners turned around and said, we won't be able to get our mortgages renewed. Businesses said that they were going to be in trouble with setting up. There was a lot of uncertainty, and there are now currently appeals. Since then, however, just a few weeks ago on February 20th, the federal government signed and released an agreement with another Native group in British Columbia called the Musqueam Indian Band. In that agreement, they said that the rights entitled to much of what is Vancouver, West Vancouver, Burnaby, Richmond, and a large part of Delta belong to the Musqueam Indian Band. But it didn't define exactly what that means. So, where are we now? By my reading of the agreement, this could lead to all kinds of uncertainty. The federal government says it doesn't change anything, and the Musqueam Indian Band say they're not coming for anybody's land. But that's the problem with agreements that are not well defined. I may not have all the answers, but I'm able to reach out to smart people who do. Dwight Newman is a professor of law at the University of Saskatchewan. He specializes in Canadian constitutional law, comparative constitutional law, and Indigenous rights law, and he joins us now. Professor Newman, thanks so much for the time on this. I've read some of what you've said publicly about this, and I see that I'm not alone in being concerned about uncertainty. Let's start with the Musqueam issue and that most recent agreement. Where does that leave things in your view? If you were a homeowner in the greater Vancouver area, would you be a little concerned?
I think it would be fair for homeowners to have some questions and to have a little bit of concern. But some of the accounts where all of their homes have already been transferred to the Musqueam vastly overstate the issue. So there's this is the problem is there's complexity on a topic where people would like simple answers. For certain purposes, the federal government has agreed with the Musqueam that they hold Aboriginal rights and title over or within that area is the phrasing. So it's not clear whether they're agreeing they hold it everywhere there or not. But the federal government would not have the jurisdiction to transfer anyone's homes. The question is what happens over the longer term, building upon this agreement, which is really an agreement about negotiating, and especially if the provincial government gets involved as well. The background claim, even though the Musqueam have said they're not pursuing individual homeowners' homes, has to cause some level of concern for homeowners.
So, this agreement on rights and title to land in the area was part of two other agreements, so three agreements in total between the federal government and the Musqueam. The other ones relating to fishing rights and coastal waters management. The agreement on land, title, and rights is very specific when it comes to the issue of what land they're talking about. And if I read it out to most people, you wouldn't have a clue because it's talking about going along the ridge and along this line to such and such a river and then down through it actually reads very similar to how our electoral districts are described by Elections Canada. From the rail line to this point and on this road, and it uses geographical markers. Roads can change, but the river's probably not going to move. And so the description of what land is covered is very, very specific, but I would say that the description of land and title is not. And so I want to read to you from section 2.1 of the agreement. And it says, the purposes of this agreement are to A, recognize Musqueam's right and title within Musqueam territory, which, as I said, already well defined, and B, demonstrate progress in incrementally implementing Musqueam's right and title. Okay, that's pretty wide open, but there is a definition section within the agreement which says, rights and title means the existing Aboriginal and treaty rights recognized and affirmed by Section 35 of the Constitution Act 1982, and for greater certainty includes Aboriginal title and self-government rights. Um, Despite the minister Minister Rebecca Alty, Minister of Crown Indigenous Relations, going on X and saying this does not impact private property rights in any way, I would look at this and say a decent lawyer taking this to court could end up opening this up to all kinds of interpretations.
There could indeed be all kinds of interpretations. Um, I guess part of what remains to be seen is what the case law is going to say about Section 35 Aboriginal title and private property, and that's being litigated in Cowichan. It's being litigated out in New Brunswick in the Wolastoqua case. This agreement, in its terms, in some ways, is bounded by what that Section 35 case law ends up saying. On the other hand, some of what it says there already goes further than existing case law. The reference to self-government actually hasn't been upheld by the courts as a Section 35 right at this stage. Maybe they will
And yet the
someday.
federal
But
government signed an agreement, and I know this is not a treaty
yeah.
or a land claims agreement, but the federal government has just signed an agreement recognizing something that has been litigated before the courts in the past.
Yeah. I mean, they're giving a particular interpretation of the case law that I think goes beyond what the case law says in that definitional clause. Now, they can negotiate things that go beyond the case law. I'm just surprised that when they're defining rights and title in accordance with what the courts have said on 35, Section 35 rights, that then they say including some things, and then they include some things that go beyond what the courts have actually said. It might be a forecast of where the courts will go, but that's not usually the way that one would end up defining it. So there's a lot of uncertainties and complexities here. There are other clauses in the agreement that try to say that it's not for the purposes of affecting litigation if things ended up breaking down in the negotiations. But what the federal government has agreed to in this could probably be invoked against the federal government if there were a court case where it were pertinent. This is what happened in Cowichan to the BC government, which got told it couldn't make certain arguments in the Cowichan case, a different case because of things it had said in the Haida agreement about the interaction of Aboriginal title and private property. So there could be unexpected effects from this agreement, not just in this area, maybe in other areas as well.
There is a part of the agreement that leaves me puzzled, and I'd like to get your view on this because while I have spent a long part of my career watching the courts, and my detractors on X like to remind me that I'm not a lawyer, that I'm not a constitutional law professor as you are, and I'm just some schmo that went to broadcast journalism at Mohawk College. I've spent a lot of time in courts covering the Supreme Court, and you get to understand the patterns, and you get to,
Sure.
whether it's patterns, precedent, you understand directions that courts could take, where things might go. But there's part of this agreement that leaves me saying, what on earth could this lead to? And it is where it says that the agreement will honor Musqueam legal tradition, the United Nations Declaration of Rights of Indigenous People, which is international law, and Canadian common law. So these are sometimes going to have competing views. Which one reigns supreme? Which one do you go with? Or is it up to the judge? Could it be up to, well, whichever way the judge or the litigants decide they want to go, their particular point of view?
Yeah, I mean, I think it could end up being up to a judge. The main purpose of the agreement is to structure negotiations. So, in the first instance, it's up to the Musqueam and the federal government coming together in those negotiations. My guess is where those sources say different things, there will be arguments by the Musqueam to take the largest and most far-reaching of those, and that might well be what ends up prevailing in negotiations. Or if it didn't, it might be what a judge would be persuaded to do.
So when Minister Alty goes on social media and says these agreements do not impact private property, this is preferred to the more uncertain alternative of determining Musqueam's Aboriginal title through the courts. By negotiating, we're able to uphold existing property rights and advance reconciliation. That's what she says. And I have no doubt that that is perhaps what the minister believes. But if this is so vague and so open to interpretation, can her word be taken as the final word?
Yeah, well, nothing here is the final word. It's an agreement to try to set in place a course of negotiations, and we don't know where those might end up. I think the minister probably is saying what she believes, to be fair. I think she believes it's not going to affect private property. Um, the Musqueam have said that they're not pursuing private property. But what happens down the road, we really don't know. And the agreement leaves some possibilities open. It may support arguments that some people could make. So there are very serious questions here. At the same time, nobody should think the sky has fallen today. It just might down the road. We'll just have to see what happens. And I know that's not a very comforting way to describe it, um, but that's sort of where we're at right now. That there's an agreement to pursue negotiations on the basis of the federal government recognizing Aboriginal title in this area. That comes with complications because there's also overlapping claims by other First Nations. So there's a bit of a mess to sort out there. But there will be negotiations within what the federal government can do based on the federal government's recognition of Aboriginal title. I emphasize that bit about what the federal government can do because largely the federal government actually can't change title to land within the province. That's a matter within provincial jurisdiction.
The current provincial government in British Columbia is run by the New Democrats, who are very much on board with implementing the Universal Declaration of Rights of Indigenous Peoples in a way that is much more liberal, progressive than the previous BC Liberal government did. I mean, they've gone much further. So, just back to the point that the Musqueam say that they're not coming for anyone's land. I do want to read a quote that was put out by Chief Wayne Sparrow, where he said, Musqueam is not coming for anyone's private property. Our approach to traditional unceded territory is one of partnership and relationship with our neighbors, not trying to take away our neighbors' private property. And I have no reason to doubt Chief Sparrow. But he is, just like the current NDP government is the current NDP government, and there will be elections. Chief Sparrow is the current chief and will not be chief forever. And someone else down the line could say, you know what, we read this very differently, and it becomes a court challenge.
Sure. So, yeah, I'd raise 2 points on his comments. So, first, you're right. The chief could change at some point. The policy of the Musqueam could change at some point. Again, whether that matters, Taiwan's home in the context of this agreement is still subject to the jurisdiction of the federal government. People should be watching what does the provincial government agree with them, because that's where things could really hit the road. However, the other piece that I would say here is that even though they're not going after anyone's home, you could say, well, then why didn't they put that in the agreement? They are actually making use of the threat to individual private property in order to try to negotiate something from Ottawa, in a sense. And so it operates as part of the background to all of this, that there be some uncertainty over what happens with Aboriginal title claims to private property, because they're going to use that as part of the negotiation with the federal government. And maybe down the road, there could be a clause that does protect private property. In the meantime, yeah, it's an uncomfortable position. There's going to be some uncertainty waved around about private property a little bit, even while they say they're not going after it, because their main objective, I think sincerely, is to try to negotiate accommodations from the federal government in light of this agreement.
So before I switch to Cowichan, where the provincial government has had to extend mortgage and loan guarantees to homeowners after that decision, um, do you know how this Musqueam agreement came about? I understand it was a long time in coming. Is this part of a an ongoing land claims process? For most of us, it seemed to come out of nowhere, but my understanding um, it's been in the works for some time.
Yeah, it would have been in the works for some time. I don't know the exact history on it, but there are First Nations claims all across British Columbia, hundreds of such claims, although the provincial government won't release an exact list. But there are hundreds of such claims, and some of them are in negotiations, and we largely don't know the exact state of those negotiations. The federal and provincial governments a few years ago agreed on the idea of pursuing sort of more interim agreements. Um, this sort of agreement, like a rights recognition agreement, fits into this model. So it hasn't resolved everything finally. It's sort of agreed on some things, set up a process, set up a dispute resolution process, and tried to set the stage for some interim accommodations, but it's not a final agreement. So there are such negotiations underway, probably in lots of contexts in British Columbia, and we just don't know about those. And it's not a very transparent way of governments going about this. I don't know that this lack of transparency is actually sustainable, given the heightened concern about these issues at the present time in British Columbia, or in Canada generally, but especially in British Columbia.
I think that the lack of transparency is at the heart of all of this and causing so much of the consternation. Let's talk about land claims in British Columbia. I've heard, people have said 120% of British Columbia is claimed by various First Nations groups. Why is the treaty system so different in British Columbia that most of the country where you reside in Saskatchewan, you've got treaties in Alberta, there's treaties in Manitoba, Ontario, Quebec. BC treaties just don't seem to exist. I know believe there's a couple, but what's the difference between British Columbia and the rest of the country?
There was at a certain stage a decision not to negotiate treaties in British Columbia. And it's a bit of a historical mystery on just why this happened in British Columbia and not elsewhere. But it was a decision by the government officials there. There's some mixed evidence on why they made that decision in terms of either they just didn't want to negotiate treaties, but there's also some evidence, and they may have been mistaken in this. They may not have been, but the governor at one point apparently thought that it was better for First Nations not to be in treaties. And those that didn't enter treaties may actually get a lot of benefits from that today. They may get much better arrangements, although they've had a long period, obviously, without having treaties, and face some consequences as a result. In different parts of the British Empire, there's some places with treaties, some without, and different writers have tried to figure out why this is, but it's just a reality that, for our purposes, that British Columbia had almost no treaties. A bit of the northeastern corner of British Columbia is in one of the numbered treaties, and there are a handful of treaties over very small areas on Vancouver Island as historic treaties. There started to be some modern treaties, but there were other parts of Canada that faced that as well. Across the north, there were no treaties. There have now been modern treaties reached across the north. Quebec was its own history there. There are some other places as well. There's some disputes in the Maritimes, and this is why we have the Wolastoqey case over whether the treaties there actually surrendered land or not, and that's being litigated there.
Well, I'm sitting right now on the land that would be called the Toronto Purchase, where the Crown purchased 250,000 acres from the Mississaugas of the New Credit, and that's been opened up multiple times. I believe the last time, unless it's been opened up again, the Harper government made a multi-million-dollar payment on top of the payments that have been made in the 1780s, the 1800s, the early 1900s. Could cases like the Cowichan, which we'll get to in a moment, or this Musqueam agreement have an impact on treaties and how land and title is viewed, rights and title is viewed in other parts of the country, such as
So,
in the Maritimes or the Prairies or Ontario?
yeah, in principle, I would say there should be no legal effect on treaties. At a practical level, I guess those in treaties see what those not in treaties are getting, and it may encourage them in trying to put some arguments. Um, the treaties across Ontario are a little bit different, or across part of Ontario, southern Ontario, tended to be smaller land purchase agreements. And then once you got to northwestern Ontario, you got more of the model that ended up becoming that of the numbered treaties. The Robinson-Huron, Robin-Superior treaties start to take some of that form, and then you get the numbered treaties across the prairies. One of the things that arose, though, is that First Nations were able to show that certain treaty terms had not been honored, and what the Harper government tried to do was set in place a process such that if they could prove that, then there could end up being compensation called a specific claim for a treaty term not being honored. And there's an ongoing process then of trying to resolve those disputes. And it is a costly process in some of these instances. Some of the agricultural clauses in the prairies are leading to payments to First Nations of hundreds of millions of dollars. And of course, the big one in Ontario, the Restool case, actually led to because of an issue where there was a determination the treaty should have had an escalating payment over time, has now led to a back payment in the range of $10 billion
Oh,
with a
wow.
B. So there's some pretty dramatic consequences from some of those, partly because of the compounding effects of interest over time. And we're talking about things that reach way back in time, and the dispute over what rate to apply makes a huge difference as well. So, yeah, there are some lingering issues there, but the issue over the ownership of the land is not there in the prairies or in significant parts of Ontario in the way it is in British Columbia.
All right. When we come back, we will talk about the Cowichan decision and see how it's different from Musqueam, how it applies, what people should know about it and be concerned about. Speaking with Professor Dwight Newman from the University of Saskatchewan. More in moments.
There were so many missed opportunities to catch this before the devastating thing happened.
A third of them we found literally in the phone book. These people were not afraid. They knew that nobody was effectively hunting them. They knew they had escaped justice, that they were going to die in their beds.
When I give talks at law schools, is that the charter ultimately is empowering a minority, and it's empowering a minority that's a guild across the country, and it's a fairly elite guild, and the guild is lawyers.
Families who were split by referendum, and brothers and sisters who never talked to each other for years after the referendum because they were so angry at each other because of emotions on both sides.
The reason he was assassinated was not because he was trying to put a satellite into space, but because the gun that he was creating had other applications that made him and the gun very dangerous.
It's finally here. A new season of Canada Did What? Host media podcast that revisits the big Canadian political events you might think you remember and tells you the real story you never knew. I'm Tristan Hopper. The voices you just heard are from our brand new Season 2. We will unpack some of the pivotal moments that helped define our country, often without a vote, usually without a plan, and sometimes without anyone admitting what they'd done. We'll find out how Canada became a welcoming paradise for untold numbers of Nazi war criminals after the Second World War. We let them build monuments to their wartime exploits and even ended up honoring a Nazi fighter in the House of Commons. And I'm sorry to say that none of that happened by accident. We'll bring you the little-known story of a troubled Canadian rocket scientist who turned to a sinister life of selling giant guns to terrible people. And if that sounds like a spy novel, it ends like one too. You'll hear the behind-the-scenes story of Quebec's attempted secession from Canada and how very close we came to a political crisis that would have made Brexit look like a picnic. You'll hear about how the much-celebrated Charter of Rights and Freedoms turned into something its creators never wanted, and how many of the most extravagant warnings about the document were all quickly proven true. And you'll even hear about how authorities bungled multiple chances to stop the deadliest terrorist attack in our country's history, and then proceeded to pretend it never happened. These aren't dusty history lessons. They're stories about power, ambition, madness, and the things about Canada that a lot of people would rather ignore. But not you. You won't want to miss an episode. Subscribe to make sure you get all of Season 2 starting March 2026, anywhere you get your podcasts.
I had said earlier that the Cowichan tribe's decision affected about 1,400 acres of land. I was wrong. It's about 18 to 1,850 acres of land in British Columbia along the Fraser River. It impacts a number of homeowners and businesses in that area. And when that decision came out, Professor Newman, it was the same sort of thing. People said, oh, no, this doesn't affect private property rights. It doesn't affect your ability to own your home. People who had to renew their mortgages were quickly finding out that they couldn't renew their mortgages. Businesses were having trouble getting financing, to the point where the NDP government of British Columbia, under Premier Eby, had to extend a $150 million loan program to help with this. What is at the core of the Cowichan decision, and is it related at all to Musqueam? Is it different? What do we need to know about this?
Okay. Well, the way it's related is complicated because the Cowichan and the Musqueam actually argued against each other in the case. So they have overlapping claims. The Cowichan succeeded in this particular case concerning a bundle of land in the city of Richmond. The Cowichan are mainly based on Vancouver Island, but they ended up proving to the satisfaction of the judge that they had a seasonal village there and that they had exclusive occupation throughout the year because other First Nations, including the Musqueam, were scared to enter onto the Cowichan land because of the viciousness of the Cowichan at the time. And there's some pretty gruesome facts
hold on.
in the
A couple
judgment
of
to
things
support
there.
that. Yeah.
A couple of things. All the grade school courses my kids were taught, First Nations were always peaceful to each other and didn't fight until colonial settlers showed up. So there's obviously that is incorrect, but we already knew that. But the federal government has just recognized this land as Musqueam territory in this agreement, but the court said, oh no, there's fishing rights for the Cowichan. So they're kind of at odds. This agreement and the Cowichan tribes ruling are at odds.
Yeah, not just fishing rights for the Cowichan, but title for the Cowichan. And that's where we get into the really significant things. So where there's Musqueam title within this area of Metro Vancouver, it can't be all of the land in Metro Vancouver, or there is a contradiction with this court decision. That's it. The court decision, let's be clear, it's under appeal. There's also an attempt to reopen it, but just taking it for what it is at the moment. The court decision back in August involved the judge making a declaration of Aboriginal title over an area and ordering the city of Richmond and the federal government to start a process on transferring the lands that they owned within that area to the Cowichan. And they gave them 18 months to negotiate about how to do that.
So just the government-owned land, though?
So just the government-owned land is ordered to be transferred, and that's all that the Cowichan sought. But they did seek a declaration of Aboriginal title over an area that did include privately owned land. And privately owned land in technical legal terms, and I don't want to go back to the feudal origins of this, but it's called fee simple land. It's the form of land holding in the technical legal term.
Does the Crown actually own all land in Canada, and then we just pay for the right to occupy it for a time?
In a sense, yeah. So you have a lesser right than the Crown by having fee simple, or there can be other kinds of fees. They don't really apply in Canada anymore. Fee simple is the normal kind of landholding that people have. But that's as large a right as one can have, in essence. You do own a fee simple. If someone passes away with no heirs, it sheets back to the Crown. So it is, in that sense, Crown land, but if you have heirs, you can pass it on to your heirs if it's fee simple land. Why I'm bringing up this technical concept is because the city of Richmond owns some of its land in fee simple, because it had received it due to unpaid taxes from people who had owned it in fee simple. So it got fee simple title to this land rather than some other government form of landholding. Because of that, the judge ends up saying things about the interaction of Aboriginal title and fee simple land. And they're a confusing mix of things, because she says at one point that the two can coexist, which doesn't make sense because each is an exclusive ownership of the land, and two people can't both exclusively own the exact same thing. They could exclusively own things next to each other, but they can't exclusively own the same thing.
You and I could
but
share a cup of coffee, but we can't both have the same cup of coffee unless we're sharing it. If
we
I
could
say it's
share
mine,
a
it's
cup
mine.
of coffee, but we can't both own the cup of coffee
Yes.
exclusively. So, yeah. So, in essence, though, the judge also ends up saying that because of the constitutionalization of Aboriginal title, parts of the BC Land Title Act are invalid, and wouldn't stand up against Aboriginal title, says various things that imply that if there were a contest between Aboriginal title and private property, the Aboriginal title might win. Now, she says, in terms of this private property that's within the area awarded to the Cowichan as Aboriginal title, but where that fee simple land, that private property land, isn't being transferred, she says, well, they would have to pursue separate proceedings to get that transferred, and maybe the private owners would still have some defense, like that they bought it innocently for value. Courts do tend to respect that, but whether that would stand against a constitutionally protected Aboriginal property right is pretty uncertain. So there's this cloud of uncertainty over the fee simple private property land that got declared to be Aboriginal title land. The owners didn't really know about this until suddenly there's this court decision, and even sometime after the court decision, the city of Richmond held a meeting a few months later, and some people were still finding out then by getting a notice of this meeting that, by the way, your land has been declared to be within an area of Aboriginal title. And then this is when banks started being unsure whether to lend on these properties,
I
or
don't blame
investors
them.
become unsure about buying the properties, and you don't blame them. No, there's some real uncertainty created for those lands. And frankly, going back to the Musqueam, but going elsewhere in BC as well, the case creates some uncertainty for private property throughout British Columbia, which is almost all subject to Aboriginal title claims, except in a few areas where those have been resolved. Now, that depends on this case being the law, and it is under appeal. It might well be framed differently by the Court of Appeal or ultimately by the Supreme Court of Canada. So the effect outside that area is smaller, but the effect on the land in the area that's been declared Aboriginal title, there's a lot of uncertainty there, and that gives rise to the issues around mortgages and so on.
My mind is going in 100 different directions with what you're telling me here, and all these
Yeah,
different
fair enough.
possibilities. And I'm thinking in particular of the Haldeman Tract, which is not traditional Aboriginal territory who occupies it now, but was a land grant given after the American War of Independence to the Mohawk and the Iroquois. And that has long been in dispute. And there's a lot of dispute about people who have fee simple title. And I can imagine every municipal government in Caledonia and Haldeman County looking at that, and the lawyers for the Confederacy of the Six Nations looking at that and saying, okay, can we apply this here? I mean, this case could open up many, many cans of worms.
Oh, it certainly opens up some big issues, and it's the first case that's really squarely confronted this. There've been a couple of others in the past that touched on it, So we knew this issue is coming, but a lot of First Nations have strategically decided not to claim against private property. And so the big 2014 Supreme Court of Canada decision in Silcotin or Chilcotin saw the Silcotin Nation or the Chilcotin Nation exclude from their claim area even the areas of private property that are located within the area that they traditionally occupied. And so there was just no dispute there. They avoided any extra complication from that. But we've now seen the next phase of First Nations starting to claim against private property. And so the Cowichan didn't ask for the transfer of the private property, but they did seek a declaration of Aboriginal title that included areas of private property. And what we've got in New Brunswick is even more dramatic. The Wolastoqey case, it's an Aboriginal title claim to half the province, and there's another one to the other half of the province. One of the challenges there is that there's actually not much Crown land in New Brunswick. And then there's this claim that the mid-1700s treaties didn't contain an explicit land surrender clause. And so there's an attempt to put these Aboriginal title claims that inevitably impact on private property. And so what the Wolastoqey did is they said they're not going to claim against individual homeowners. They made up this category they called the industrial defendants. But in essence, it's large landowners that have their land to make profits from the land. And they said they are claiming that land. Well, the New Brunswick Court of Appeal has shut that down subsequently to Cowichan and said, no, you can't claim Aboriginal title from private property owners. However, there might be compensation that owes from the Crown for that. And that's a separate issue that will be examined further. Now, the Wolastoqey are seeking leave to appeal this to the Supreme Court of Canada. They would like the Supreme Court of Canada to say, actually, there can be Aboriginal title claims to private property. So we might see the Supreme Court of Canada engage with this question sooner than later if they decide to hear an appeal from this interim decision in New Brunswick. And I know there's so many complications to all of this. Listeners must be struggling. You need big charts to keep track of all of this, but this is where we're at.
Yeah, you need one of those charts that they use for finding the suspect and the connections on the cop TV shows. Would the Supreme Court wait for Cowichan and the New Brunswick case to hear them at the same time, or would they necessarily just say, no, we'll hear them individually?
They'll hear them individually. They're too far apart in time. So either they don't hear Wolastoqey, or if they do, they'll hear it first. Because Cowichan, there's this complicated attempt to reopen the trial decision. Some of the private landowners are arguing that the trial judge should reopen it and hear from them before finalizing the judgment. Whatever happens with that, then it's going to take time to go to the Court of Appeal, and it would only be after that there could even be an attempt to go to the Supreme Court of Canada. So it's years away from the Supreme Court of Canada. The Wolastoqey case, the court could decide in the next 6 months whether they'll hear it, and if they're going to hear it, it would be in the next year after that.
Okay. How much of this is related to Canada deciding to adopt the United Nations Declaration for the Rights of Indigenous Peoples? Because it comes up in the Cowichan decision. I'm sure it comes up in the New Brunswick case. It comes up in the Musqueam agreement. I remember, originally the Canadian government was opposed to adopting UNDRIP, as they call it, saying that it would have impacts like this. And I remember in 2010, when the Harper government was moving towards adopting this, I said, are you guys sure this is going to cause all kinds of problems? Oh, no, they said. This is largely symbolic, which seems quaint now because UNDRIP has been integrated into federal law, in British Columbia especially. It has been integrated into provincial law, and it's showing up in court decisions and agreements. It is the United Nations Declaration on the Rights of Indigenous Peoples moving Canadian law further away from where it would have been if this had not been otherwise adopted?
It's actually tough to say that it's had a major impact on these cases. These cases follow on a line of case law about Aboriginal title developed under Section 35 of Canada's Constitution Act 1982. Now, there's a little bit of reference to UNDRIP in the cases. In the Cowichan case, there's a bigger reference to the Interpretation Act amendment, which was done there. So what British Columbia did is they said that they're passing legislation to implement UNDRIP, and they said they're going to amend. They said a couple of years later they'll amend British Columbia's Interpretation Act to say that every judge reading a statute needs to read that consistently with UNDRIP where possible. And then actually it's not even as much in Cowichan, but in the subsequent decision, Gikala, which is about the mining system in British Columbia, the court ended up saying, well, they can now actually reread every British Columbia statute in light of UNDRIP. And they can make declarations that statutes are not consistent with UNDRIP. And part of that, the BC government invited with amending the Interpretation Act. They shouldn't be surprised when courts then follow that provision. The decision that courts would start striking down statutes for inconsistency with UNDRIP is, to be fair, I think a surprise. I think that's beyond what the statute was ever meant to do, the Declaration on the Rights of Indigenous Peoples Act. But both British Columbia and the federal government have these statutes, and it's because of those statutes to a significant degree that you've had some courts making some statements about UNDRIP being part of Canadian law, which is technically right. It's been brought into Canadian law at the federal level and in British Columbia, but then they're using it in other ways to affect reasoning that probably don't follow from that. There's a big case in Ontario on the duty to consult in the federal courts. The Cowichan and Canadian Nuclear Laboratories case. An appeal was just heard at the Federal Court of Appeal in October. But before that, the trial judge said, well, UNDRIP has become part of Canadian law, therefore she'll modify the duty to consult doctrine to fit better with UNDRIP and shift it to free, prior, and informed consent. And I think it's a really problematic decision because the duty to consult is a constitutional doctrine under Section 35, and she was relying on the federal statute, and the federal government passing a statute can't change constitutional law in any logical way, but UNDRIP is getting here and there into the reasoning of courts. I'm not sure it's determinative in the Cowichan case, but it is becoming a big factor in the courts, for sure.
And this is what makes me uncomfortable with it, is that UNDRIP is not a Canadian law or statute. Yes, we can implement it through Canadian law and statute, but it is fundamentally an expression from an international body. If we had wanted to say, all right, well, we want to implement all of that and put it in Canadian law specifically and not rely on the United Nations, that would be one thing. But farming out your law to a different organization that none of us can elect or vote out always leaves me a little bit uneasy. And it's, as you say, now judges are reading it as superseding the Constitution, which should never happen. So a lot of unknowns. I turn to you, Professor, to try and clear things up. And you give students a passing or failing grade all that time. I think I'm going to have to say that you failed me in clearing things up, but that is not your fault.
Fair. No, this is my worry. I've come here and you asked me to bring clarity, and I'm probably just bringing more questions and problems for listeners. But that's just trying to accurately describe the state of things in Canada on these issues right now. And this is, I think, why we're seeing a lot of discussion, starting from Cowichan, but also these later cases. Suddenly, Canadians are seeing there's some real impacts from these on everyday Canadians that could well occur. But we don't know what those are, and it's really complex to even try to talk about what those might be, but we're trying to get through them a little bit here in our discussion.
I do appreciate you at least attempting to bring clarity where it's difficult to see through the mud. Thanks so much for your time today.
Okay, thank you.
Full Comment is a post-media podcast. My name's Brian Lilly, your host. This episode was produced by Andre Prue. Theme music by Bryce Hall. Kevin Libben is the executive producer. Please remember to hit the subscribe button, leave us a review, share it on social media, and thanks for listening. Until next time, I'm Brian Lilly.
There were so many missed opportunities to catch this before the devastating thing happened.
A third of them we found literally in the phone book. These people were not afraid. They knew that nobody was effectively hunting them. They knew they had escaped justice, that they were going to die in their beds.
When I give talks at law schools, is that the charter ultimately is empowering a minority, and it's empowering a minority that's a guild across the country, and it's a fairly elite guild, and the guild is lawyers.
Families who were split by referendum and brothers and sisters who never talked to each other for years after the referendum because they were so angry at each other because of emotions on both sides.
The reason he was assassinated was not because he was trying to put a satellite into space, but because the gun that he was creating had other applications that made him and the gun very dangerous.
It's finally here. A new season of Canada Did What? Host media podcast that revisits the big Canadian political events you might think you remember and tells you the real story you never knew. I'm Tristan Hopper. The voices you just heard are from our brand new Season 2. We will unpack some of the pivotal moments that helped define our country, often without a vote, usually without a plan, and sometimes without anyone admitting what they'd done. We'll find out how Canada became a welcoming paradise for untold numbers of Nazi war criminals after the Second World War. We let them build monuments to their wartime exploits and even ended up honoring a Nazi fighter in the House of Commons. And I'm sorry to say that none of that happened by accident. We'll bring you the little-known story of a troubled Canadian rocket scientist who turned to a sinister life of selling giant guns to terrible people. And if that sounds like a spy novel, it ends like one too. You'll hear the behind-the-scenes story of Quebec's attempted secession from Canada and how very close we came to a political crisis that would have made Brexit look like a picnic. You'll hear about how the much-celebrated Charter of Rights and Freedoms turned into something its creators never wanted, and how many of the most extravagant warnings about the document were all quickly proven true. And you'll even hear about how authorities bungled multiple chances to stop the deadliest terrorist attack in our country's history, and then proceeded to pretend it never happened. These aren't dusty history lessons. They're stories about power, ambition, madness, and the things about Canada that a lot of people would rather ignore. But not you. You won't want to miss an episode. Subscribe to make sure you get all of Season 2 starting March 2026, anywhere you get your podcasts.